Donald Trump has just threatened to sue Trevor Noah, not over a news report, not over an investigation, but over a joke, a roughly 30-second bit at the Grammys referencing Jeffrey Epstein's island. And here's what almost no one is saying out loud. This isn't about defending Trump's reputation. This is about using defamation law as a weapon to shut people up. And from a prosecutor's point of view, Trump may have stepped straight into a legal minefield, one that could expose far more than he bargained for. Pay close attention to what happens next. Sunday night, February 1st, 2026, the Grammy Awards. Trevor Noah is hosting for the fifth and final time. Billie Eilish wins Song of the Year for Wildflower. Noah delivers a joke. That's a Grammy every artist wants almost as badly as Trump wants Greenland, which makes sense, because Epstein's island is gone. He needs a new place to hang out with Bill Clinton. The crowd laughs. Then Noah adds, "I told you it's my last year. What are you going to do about it?" By 10:01 a.m. The next morning, Trump fires back on Truth Social, not with a quick denial, but with a 300-word threat. Let me read you the key parts. Noah falsely stated that Donald Trump and Bill Clinton spent time on Epstein Island. Wrong. I can't speak for Bill, but I have never been to Epstein Island or anywhere near it. And until tonight's false and defamatory statement, I have never been accused of being there. Not even by the fake news media. Then comes the threat. Noah, a total loser, better get his facts straight. And fast. It looks like I'll be sending my lawyers to sue this poor, pathetic, talentless dope of an MC for plenty. Ask little George Stephanopoulos and others how that turned out. Also ask CBS. Get ready, Noah. I'm going to have some fun with you. Trump is clearly pointing to his recent settlements. ABC News paid him $15 million after George Stephanopoulos said Trump was liable for rape, when the actual legal finding was sexual abuse. CBS paid $16 million over an edited 60 Minutes interview. So Trump feels untouchable. But here's where this becomes dangerous for him. Think about it carefully. What Noah said wasn't a news report asserting a fact. It was a joke, told by a comedian at an awards show, in front of millions of people who understood it as satire. And satire about public figures carries very different legal protections than journalism. But there's more. Something Trump's lawyers should have caught before he hit post. On January 30th, just 3 days before the Grammys, Trump's own Justice Department released more than 3 million pages of Epstein-related files. The Deputy Attorney General, Todd Blanche, stood at a podium and told the country, "These files represent full compliance with the Epstein Files Transparency Act. So, what's inside them?" Trump's name appears more than 3,000 times. Let that sink in for a moment. The files include emails where Epstein and his associates shared news articles about Trump. They also include photographs of Trump at Epstein's properties. There's a 220 email from the Southern District of New York stating, "Donald Trump traveled on Epstein's private jet far more times than previously reported or than we were aware of." The files even include testimony from one of Epstein's victims, who said Ghislaine Maxwell made it clear she was available for Trump and his friends. Now, the file notes that nothing ultimately happened, but Maxwell's statement suggested the arrangement. There's also testimony from Trump's own Mar-a-Lago butler, who said Trump and Epstein socialized frequently, though Trump usually ate in the kitchen rather than at the main table. Now, Trump has repeatedly denied any wrongdoing. He has never been charged with a crime connected to Epstein, neither has Bill Clinton. Both men deny knowing anything about Epstein's criminal activity. But here's the prosecutorial question. If you're about to sue someone for defamation over a joke linking you to Epstein's island, do you really want to open discovery on your relationship with Jeffrey Epstein? Because that's exactly what a lawsuit would trigger. Noah told a joke. Trump's response, "I'll send my lawyers." But before we explain why this lawsuit is almost certainly doomed, we need to understand what Trump is actually trying to accomplish here. And it's not about winning in court. Here's what most people aren't telling you about Trump's litigation strategy. Trump doesn't sue to win trials. He sues to create fear. From a prosecutor's standpoint, the pattern is obvious. Trump has filed dozens of defamation lawsuits over the years. He settles some, he loses most. But the outcome isn't the point. The threat is. When Trump sued ABC and CBS, those were major media companies with deep pockets and massive legal teams. They chose to settle rather than fight through years of expensive litigation, even though both had strong First Amendment defenses. ABC paid $15 million, CBS paid $16 million. That's $31 million over statements that were arguably true, or at least substantially accurate, just not perfectly worded. Now Trump is using the same playbook on a comedian. But here's what makes this different. Noah made a joke, not a factual claim. And under First Amendment law, specifically the Supreme Court's 1988 decision in Hustler magazine v. Falwell, satire and parody about public figures receive the strongest constitutional protection available. Let me break down the legal standard. To win a defamation case, Trump would have to prove 4 things. First, that Noah made a false statement. Second, that the statement referred to Trump. Third, that it was communicated to third parties. And fourth, that it caused real damage to Trump's reputation. But Trump isn't a private citizen. He's the president of the United States. That makes him a public official, which triggers a much higher legal bar under New York Times v. Sullivan from 1964. Trump would have to prove actual malice. That's not just a phrase, it's a precise legal standard. It means Noah either knew the statement was false or acted with reckless disregard for whether it was true or false. And here's Trump's problem. You can't prove actual malice when the statement is clearly a joke. In Hustler v. Falwell, the Supreme Court dealt with this exact issue. Hustler magazine ran a parody implying that Jerry Falwell, a well-known televangelist, had an incestuous encounter with his mother in an outhouse. Falwell sued for defamation and intentional infliction of emotional distress. The court ruled unanimously against him. It held that parody, no matter how outrageous or offensive, cannot be defamatory if no reasonable person would believe it was stating real facts. Chief Justice Rehnquist wrote, "The sort of robust political debate encouraged by the First Amendment is bound to produce speech that is critical of those who hold public office. Such criticism will not always be polite or restrained." The court went further. If we were to rule otherwise, there is little doubt that political cartoonists and satirists would face damages awards without any showing that their work falsely defamed its subject. Now, apply that reasoning here. Did any reasonable viewer watching the Grammys believe Trevor Noah was delivering verified reporting? Or were they watching a comedian hosting an awards show, making a satirical reference to Trump's well-documented association with Jeffrey Epstein? The audience laughed. That matters. Laughter is evidence that people understood the comment as humor, not journalism. But Trump faces another problem, and this one is strategic. If Trump actually files this lawsuit, he opens the door to discovery. Let me explain what that means in real terms. Discovery is the pre-trial phase where both sides can demand documents, take depositions, and compel evidence. It's the most powerful weapon in civil litigation, because it forces disclosure of information a party would never voluntarily hand over. If Trump sues Noah over the Epstein joke, Noah's lawyers can subpoena every communication Trump ever had with Jeffrey Epstein. Every email, every text message, every phone record, every flight log. They can depose Trump under oath about how he met Epstein, how often they socialized, whether Trump visited any of Epstein's properties, and what Trump knew about Epstein's conduct with young women. They can subpoena Mar-a-Lago employees. They can depose anyone who witnessed Trump and Epstein together. They can comb through every DOJ document just released and ask Trump detailed questions about each one. Why would a prosecutor ever take that risk? They wouldn't, not if the real goal was to win the case. But Trump isn't thinking like a prosecutor. He's thinking like a politician using litigation as leverage. Now look at the timeline. January 30th. The Department of Justice releases roughly 3 million pages of Epstein-related files. The administration claims full compliance with the Epstein Files Transparency Act. But congressional Democrats immediately push back. Representative Ro Khanna, a co-sponsor of the law, says the DOJ identified more than 6 million potentially responsive pages, yet released only about half. That raises a simple question: where's the rest? Representative Robert Garcia, the ranking Democrat on the House Oversight Committee, goes even further. He says Trump's DOJ is withholding nearly 50% of the Epstein files while claiming full compliance with the law. So Trump is under political pressure. His administration is accused of hiding information. Democrats are demanding the remaining 3 million pages. Then, just 3 days later, Trevor Noah makes a joke on national television linking Trump to Epstein's island. And Trump responds with a lawsuit threat. Why? From a prosecutor's perspective, this looks like narrative control. Instead of defending against accusations of a cover-up, Trump goes on offense. He reframes himself as the victim of false attacks, using the joke as proof of unfair treatment. But look closely at what Trump actually said on Truth Social. He claimed he's never been to Epstein's island, nor anywhere close, and that before Noah's joke, he had never even been accused of being there, not even by the fake news media. Is that accurate? Technically, most reporting has focused on Trump's social relationship with Epstein, his trips on Epstein's plane, and the allegations referenced in DOJ materials. Very few outlets have explicitly said Trump visited Little St. James, Epstein's island in the U.S. Virgin Islands. But here's the catch. Noah didn't say Trump went to the island either. Listen to the joke again. Epstein's island is gone. He needs a new one to hang out with Bill Clinton. The joke is about Trump wanting Greenland as a replacement island, not a claim that Trump visited Epstein's island. It's satire built on layered references. The joke only works if you understand that context. So Trump's lawsuit threat rests on either a misunderstanding or a deliberate distortion of what Noah actually said. And that becomes a serious liability if this ever reaches a courtroom. But there's still more. The DOJ files released on January 30th contain material that directly undercuts Trump's claim that he was never connected to Epstein's properties. Photographs place Trump at Epstein's Manhattan townhouse. Flight records show Trump aboard Epstein's private plane. Witness testimony places Trump at Epstein's Palm Beach residence. Now, being present at someone's property isn't a crime. And Trump has long acknowledged that he socialized with Epstein in the early 2000s, saying he cut off contact around 2004. Years before Epstein's crimes became public. But if Trump sues Trevor Noah over a joke involving Epstein's island, all of this becomes fair game in discovery. Noah's legal defense would be straightforward. Truth is an absolute defense to defamation. If Noah can demonstrate that Trump had extensive contact with Epstein, visited multiple Epstein properties, and appears thousands of times in federal investigative files, then a satirical joke, not a factual claim, is constitutionally protected speech. And that's before you even reach the actual malice standard. This goes far beyond one lawsuit. What Trump is doing fits into a broader pattern of using defamation law to intimidate critics. And it works. Not because he wins in court, but because the threat alone alters behavior. Think about the calculation facing a news outlet or a comedian. Even if a statement is accurate but phrased imprecisely, the risk is enormous. Years of litigation and potential multi-million-dollar settlements. The legal costs alone can be crushing. ABC and CBS didn't settle because they were wrong. They settled because defending constitutional principles is expensive and time-consuming. 15 million, 6 million. Those are business decisions, not admissions of guilt. But look at the broader impact on democratic accountability. If journalists and commentators know that criticizing powerful figures could mean years of lawsuits and financial exposure, they'll self-censor. They'll soften language. They'll avoid aggressive investigations. That's not just bad for journalism. It's dangerous for democracy. The Supreme Court recognized this risk back in New York Times versus Sullivan in 1964. The court emphasized that First Amendment protections must provide breathing space for open debate, even if that means protecting some statements that later turn out to be inaccurate. Justice William Brennan wrote that the Constitution must protect even vehement, caustic, and sometimes unpleasantly sharp attacks on public officials, because the alternative is a society where critics are afraid to speak at all. Trump's litigation strategy exploits the gap between legal theory and real-world consequences. Yes, Trevor Noah would almost certainly prevail if Trump sued, but the process itself becomes the punishment. There's also another consequence that isn't being discussed enough. If Trump actually files this lawsuit and discovery begins, the opposing side gains the right to scrutinize every aspect of Trump's relationship with Epstein. That means hours, possibly days, of depositions. It means document production. It means sworn testimony. Trump's lawyers know this. They have to know this. So why issue the threat? Because Trump is betting that Noah won't want years of litigation, that CBS won't want another defamation fight, and that the threat alone will make comedians think twice before joking about Epstein. But here's where that calculation may break down. Trevor Noah isn't a news organization dependent on sources or political access. He's a comedian nearing the end of his hosting run. He's said it himself, "It's my last year. What are you going to do about it?" And satire receives the strongest First Amendment protection of any form of speech. Courts have repeatedly held that jokes about public figures, even harsh or unfair ones, are protected unless they make specific false factual claims that cause reputational harm. So if Trump files this suit, he's choosing the worst possible test case for his strategy. He'd be suing a defendant with ironclad legal defenses, and nothing to lose. And in the process, he'd be opening himself up to discovery on his most sensitive political vulnerability. That's not strategy, that's hubris. From a prosecutor's perspective, Trump's Truth Social post reads like a warning to other critics. Look what I did to ABC and CBS. I'll do it to you too. But the legal system doesn't work the way Trump wants it to. Courts can distinguish between factual reporting and satire, judges can dismiss meritless cases, and discovery rules apply equally to both sides. Here's the key point. Trump's threat against Trevor Noah isn't an isolated incident. It's part of a broader pattern of using litigation to chill speech. And whether or not Trump ever files the lawsuit, the threat itself has already done part of its job. But there's a cost Trump may not have fully considered. Every lawsuit threat, every settlement, every legal maneuver draws attention back to the underlying facts. The ABC settlement revived focus on the E. Jean Carroll verdict. The CBS settlement raised broader questions about interview editing practices. And this lawsuit threat is driving millions of people to search for the Trump-Epstein files to understand what Noah was joking about. Sometimes the attempted suppression, or in this case the legal threat, attracts more attention than the original issue ever would have. The rule of law depends on accountability, even for the powerful. Journalists must be free to investigate without fear. Comedians must be free to satirize without censorship. Citizens must be free to criticize their leaders without legal retaliation. Trump's defamation strategy threatens all of that, not because the cases are legally strong, but because the process itself discourages speech. So watch what happens next. Will Trump actually file? Will Noah and CBS push back? Will this become another Hustler v. Falwell moment where the courts reaffirm that satire is protected speech?